On that note, I'll hand over to Advocate Nema Sisi, who will continue with the second portion of the presentation. Thank you.
Thank you so much, and thanks to the chairperson of the Information Regulator. Just a bit of correction, I am an attorney, I'm not an advocate. We can go to the next slide, 16, please. Thank you so much. My first presentation will deal with the regulator state of readiness. And as you are aware that on the 1st of July, all responsible parties must ensure that all processing of personal information complies with POPIA. And this is the period in which the information regulator enforcement power will come into effect. As you are aware, currently we are in the grace period. The legislation provided for a period of 12 months grace period in terms of which responsible parties were given opportunity to ensure that their processes are in line with POPIA. And this grace period comes to an end on the 30th of June, which is the 1st of July. All processes must be in compliance with POPIA, which means if you are not in compliance, will definitely, regulator will then enforce compliance. On the 30th of June, Chairperson indicated this, that the regulator will be responsible for the promotion and enforcement of the rights protected by POPIA, which means the function which is currently performed by the South African Human Rights Commission will therefore be taken over by the information regulator. And therefore, any request for access to information which is being denied, the public will have opportunity, instead of going to court, they will now lodge their complaint with the information regulator. Although this is not a preemptory, you can decide if you want to lodge a complaint with the regulator, you can do so, or if you want to go to court, you can go to court. But the advantage of going to the information regulator with regard to the POPIA request is that the cost, there's no cost for doing so, but going to court, obviously, you might need a lawyer to represent you. So the regulator is here to obviously to ensure that everyone has access to justice or to information without having to incur any cost. Next slide, please. So on the 1st of July, Section 58.2 of POPIA will also come into operation. And this is the section regarding the prior authorization. I will deal with the issue of prior authorization at the next slides. But this section the regulator have now determined the 1st of July as the date in which this section will come into operation. Next slide, please. There are regulations which are made by the regulator in terms of Section 112 of POPIA, and those regulations have now been, the regulator have now pronounced that Regulation 5, you know that all the regulations initially were not in operation, and the regulator had indicated that it will specify when those regulations will come into operation. And so in order to ensure that there is compliance, responsible parties are given opportunity during the grace period to ensure that their processes are in compliance. Regulation 5, which deals with the issuing of code of conduct, has come into operation on the 1st of March, which means that now people can make applications for code of conduct, not necessarily people, let me say, relevant bodies and associations similar to the Institute of Commercial Forensic. They can, if they wish, they can make an application for a code of conduct. That code of conduct will regulate their industry. So you can, effective from the 1st of March, the regulator has been accepting code of conduct, and we're currently processing some of the applications that we've received. And then also Regulation 4 will come into operation on the 1st of May. This is the regulation that deals with the responsibilities of information officers. This will assist the information officer in the meantime to ensure that certain responsibility, which I'll deal with them shortly as well, in preparation for the 1st of July, those are done. Chairperson mentioned about the issue of security measures. Those need to be done before the 1st of July, because 1st of July, if you don't have adequate security measures, it means the regulator will enforce and compliance. And you know that there's a penalty of about maximum of 10 million that the regulator can impose. So this regulation has come into operation to ensure that the preparatory work is done by the information officer. The rest of the regulations that are issued will come into operation on the 1st of July. In essence, it means the regulator currently handles complaints, but in the 1st of July, that would be fully functional in terms of which complaints will now be accepted and investigated, and enforcement will be in effect. So that the rest of the regulation will come into operation on the 1st of July 2021. That's about in the next 2 months. Next slide. We indicated about the regulation 5 that talks about the information officer. You'll notice that both POPIA and POPIA requires each public and private body to appoint an information officer and to designate and delegate a deputy information officer. Maybe before we go to the next slide, I just want to qualify this. The appointment of information officer, it's automatically by operation of the law. In other words, you don't necessarily have to go and say you're going to appoint them as the information officer. So by virtue of the position, so if you have got a CEO in your organization, by virtue of his position as the CEO, he is automatically an information officer, and he has to be registered with the information regulator. And the CEO does have a power to designate or delegate certain powers to the deputy information officer. It's an option that the CEO will have as a head of institution. Next slide. So what are the duties and responsibilities of the information officers? And that's the reason why Regulation 5 is now coming to operation, to ensure that information officer will start implementing their duties now in preparation for the 1st of July. So the first duty of the information officer is encouragement of compliance with the condition for the lawful processing of personal information. The 8 conditions which the chairperson went through, those are the conditions that the information officer was the CEO for the private companies. Some companies does not have a CEO, they've got general managers. Depending on the structure of that company, the person who's the head of that institution is the one who's the information officer. That person has got a responsibility to ensure that the 8 conditions with the chairperson highlighted needs to be complied with by the organization. The information officer does also have a responsibility dealing with the requests made to the body pursuant to POPIA. You'll know that if I want to object to the processing of personal information in terms of one of the 8 conditions, you have to allow me to object to that. If I want my information to be deleted under POPIA, as an information officer, you have a responsibility to ensure that such a request is dealt with. Also, the information officer is required in terms of the Act to work with the regulator in relation to investigation conducted pursuant to Chapter 6. In other words, if there's a complaint against a responsible party, the information officer does not have a right to say, I'm not going to assist the information regulator. The Act requires the information officer to work with the regulator in relation to that investigation. It's an obligation that the information officer must do so. Next slide, please. The information officer also has to ensure compliance by the body with the provision of POPIA. I've highlighted this, that there is an obligation of the information officer to ensure compliance. And this is because you are, as the head, anything that happens in the institution, as the information officer, you need to make sure that the organization complies with the legislation. The element of accountability rests with the information officer, who's the head of the institutions. Also, the information officer must ensure that a compliance framework is developed, implemented, monitored, and maintained. So this is a document that obviously the organization will have developed as a compliance framework. The information officer also, and this is very critical, the information officer also has to ensure that a personal information impact assessment is done to ensure that adequate measures and standards exist in order to comply with the condition for the lawful processing of personal information. The best time to do, I'll say, to develop the compliance framework to ensure that personal information impact assessment is done, it's now. The next 2 months is the best time to do that, because having developed the compliance framework, having done the personal information impact assessment now, it means the 1st of July, your organization will be, you will know what is that need to be done, and it will be compliant at that time, because we're left with only 2 months. These are the most critical documents or processes that needs to be done by the information officer during this grace period. Next slide. The information officer, you know, in terms of POPIA, remember the information officer under POPIA is the same information officer under POPIA. So the information officer under POPIA are required to develop a manual. We call it a POPIA manual. And that POPIA manual has to be developed, monitored, and maintained, and must be made available as prescribed. One of the requirements is that you must have a hard copy at your reception, where if any person wants to view that manual, it should be available at the reception, at your reception. You need to have that manual as well on your website. So if you've got a website, if people request for a copy of that, if they want to view the copy of your manual, it must be available on your website. Those are the main place where you need to have it. Also, people can request a copy of your manual, which you need to provide that manual. I would like to advise here that the requirement for POPIA manual have now been amended by POPIA. And I would like to refer the responsible parties that they should visit section 14, or the relevant one here would be section 51, because that's the one that deals with the private bodies. You will see that the manual now has to be amended. If you have a manual currently, which was done under the current POPIA, I would like you to start the process of reviewing your manual to be in line with the section 51 as amended, that now incorporate the processing of personal information, where you have to specify, for example, the reason why you process personal information. That has to be contained in the POPIA manual. You need to specify whether you are going to transfer that personal information outside the border of the country. You need to specify what are the security measures that you have insofar as the processing of personal information are concerned. Those are the information that are now, some of the information that are now required in your POPIA manual, which means we need to start amendment or reviewing of that POPIA manual to ensure that it's in compliance come the 30th of June. We should be our POPIA manual must be in compliance when section 110 of POPIA comes into operation. The information officer also has to ensure that internal measures are developed together with adequate system to process requests for information and access to. Normally this, you can do it in terms of, you can have a policy which deals with how you're going to attend to any request for information or access to information. But the manual also will cover that aspect as well. So, but the information officer has that responsibility to ensure that those internal measures are developed to ensure compliance with the legislation. The other responsibility of the information officer is to ensure that internal awareness sessions are conducted regarding POPIA, its regulation and code of conduct. I mean, we can give an example of this session that we're now having. It's part of a session that you may want to have. You can I invite attorneys who have got expertise in POPIA or POPIA to conduct some workshop for you. You can even, if you've got internal capacity, maybe your legal department, your compliance department, conduct those internal awareness sessions to ensure that the employees who are processing personal information, they have got updated information about how such information should be processed. The information officer also must take up their duties only after the responsible party has registered them with the regulator. Remember, in terms of section 55, the information officer must be registered with the information regulator, and a guidance note in this regard has been issued. And I request that if you have got time, you can go to our website, go through the guidance note where it extensively deals with what are the expectations, what are the requirements, and of the information officer and how to register your information officer. Next slide. We talked about the designation and delegation of deputy information officers. And these are the prerogative of the information officer. So the CEO, for example, of an organization can actually designate a person as a deputy information officer. So designated, in other words, you have got employees within your organization, and obviously you need to designate a person who would be able to assist you, because the purpose of designation is to ensure access. If you're a big organization, our advice is that the information officer should consider the designation of deputy information officer, because the CEO may not be readily available to attend to all the requests under POPIA or under POPIA. So the deputy information officer are designated to assist the information officer in processing any requests that are made under POPIA and POPIA. And this is not a compulsory, it's a discussion that you have for you to be assisted, because remember the element of accountability. Under POPIA, there's a criminal element attached to the information officer. And under POPIA, this is the responsible party that's supposed to take accountability. But you need to ensure that you're accessible. So if you are not, the public will lodge a complaint with the regulator, and that obviously the regulator may issue enforcement notice or administrative fine for non-compliance. So it is important to consider this aspect of whether you want to designate. You can designate more than one deputy information officer. I'll give an example. If you are a national entity meaning you've got branches across the country, you're not only operating in one province. Our advice would be you should consider to have a deputy information officer in each office. This is not a separate appointment that you need to appoint a person as a deputy information officer. It's within your current structure. You can just say, designate one person to do over and above their responsibility to assist you should there be any request made under POPIA or POPIA. The issue of delegation of authority. So you can designate, meaning when you designate only, you do not have, the person who's designated does not have power to take a decision. In other words, if there's a request for access to personal information, the designated person does not have power to take a decision whether to grant access or to refuse access. But you can also designate and delegate powers to that deputy information officer or to all deputy information officers that you have. So once the power are delegated, so it means the person that you need to delegate, it has to be a senior person who will have some element of accountability and will assist you in taking those decisions, because if they make a wrong decision, you still remain accountable as an information officer. So as you delegate the powers, the deputy information officer, it has to be somebody that you trust that they'll be able to execute your mandate appropriately. And that can be done as well. And you see there's a template for delegation designation in the guidance notes that the regulator has issued, which is available on our website. So you can view that. That template can be used for you to be able to delegate that. And as I indicated, once you delegated, the delegated person will be able to take a decision on your behalf, but you remain accountable for that decision. As I indicated, the guidance note has been issued. It is available on our website. Next slide. Maybe before I go to the guidelines, this guidance note, the session will commence on the 1st of May. We are in the process of finalizing the portal, online portal. Because of capacity, we will not be able to process manual applications. And so we request that the responsible parties, when they register their information officers, they will issue a public notice wherein we'll provide a link where the responsible parties will be able to lodge their registration of information officer online, which the process, we do not anticipate it to take more than 30 minutes. And upon completing your application online, the system will automatically issue you with a certificate of registration. So if you have already designated or delegated certain power to a deputy information officers, that information must be also completed in an online registration form. And if you have a deputy information officer, your certificate will be different from the person who do not have a deputy information officer, because the certificate will contain the name of the deputy information officer that you have. So that will be an automatic certificate that will be issued by the system. And you can download that certificate, put it in your website, or print it and put it somewhere wherein a person can, when our compliance officers conduct an assessment, if they ask you whether you're registered your information officer or not, you should be able to show proof that you are registered. And that proof, if anyone requests that, you need to be able to provide that. And once you're registered, if the CEO or any deputy information officer that you have resign, or for any reason resigned, you need to update your information. That will be done as well online as well. Once you update the certificate, new certificate will be issued. So now the guidelines for development of code of conduct. POPIA empowers the regulator from time to time to issue, amend, revoke codes, and to prepare written guidelines that would assist bodies to develop or to apply code of conduct, to approve the code, and also to consider afresh upon application the determination by adjudicators under approved code of conduct. So the purpose of the code is to establish a voluntary accountability tool and to promote transparency for relevant bodies on how personal information should be processed. And the code do not replace relevant provision in POPIA, but it operates in support of the requirement of POPIA. Next slide. So a code of conduct cannot limit a data subject right to privacy as provided for in POPIA. So in other words, when you develop a code, you should not do a code that then limit that rights that are provided in the Constitution as well as in POPIA, because the code of conduct it's just a subsidiary piece of regulatory instrument that the regulator may issue. So if your draft code of conduct that you submit the regulator for approval does not comply with the POPIA, that code of conduct will not be approved, it will be rejected. So the relevant bodies bound by issued or approved code of conduct must not perform an act or engage in a practice that breaches that approved code. So once the code is approved, you need to ensure as the responsible parties under that relevant body, you need to ensure that your processes are in line with the code of conduct that has been approved. So a breach of the approved code of conduct is deemed to be a breach of the condition for the lawful processing of personal information, and such will be dealt with under Chapter 10. That means that if a code of you submit to the regulator as a body, relevant body, a code of conduct, the regulator approved it and issued, and one of the responsible party under the code of regulated by the code of conduct breached that code of conduct is deemed as the breach of the condition for lawful processing of personal information, and automatically the regulator will then enforce that compliance in terms of its powers under POPIA. Next slide. So the reason for developing a code may include, for example, providing clarity on how the condition for lawful processing of personal information are to be applied and complied with given the particular features of the relevant body, providing a functional equivalent means of fulfilling the obligations related to the condition for the lawful processing of personal information, and also it may include promoting an organizational paradigms which shift, paradigm shift change in the relevant body relating to lawful processing of personal information. Next slide. It also includes stipulating condition for lawful processing of personal information for specified information or class of information. Also includes stipulating condition for the lawful processing of personal information for any specified activity or class of activity. It can also outline the rules and procedure for information matching programs if such programs are used with within a specific sector. Next slide. The code of conduct also, the purpose would be to outline how the legitimate interests of data subject are to be protected insofar as automated decision-making affect them, enabling the review of a code of conduct, providing details regarding the expiry of the code, and providing a procedure of dealing with the complaints. There are instances where in a code of conduct, so a code of conduct can have a procedure for dealing with the complaints. Some code of conduct will not have that, but once you put a procedure for dealing with the complaints, an adjudicator will be appointed, meaning that complaints will dealt with it internally, and only if a person is not satisfied with the decision of the regulator, sorry, of the adjudicator, then they can refer their complaint to the information regulator for final adjudication. Next slide. So the update on the code of conduct, you remember in 2019, the regulator drafted the guidelines for the development of code of conduct. That guideline was published for comment, and there was a consultative workshop that were done before the COVID. More than 600 written submissions from 14 organizations were received. The regulator has now published the guideline to develop a code of conduct in the Government Gazette, which come into effect on the 1st of March. As I've indicated, now you can submit your application for a code of conduct to be issued. It's the best time to do it now, because if you don't, you will see when we talk about the issue of exemption or prior authorization, that if there's no code of conduct issued, that means you must have to apply for prior authorization. And also the regulation 4 will come into effect on the 1st of May. And and Regulation 5 on the 1st of March, and residual regulation, as I've indicated earlier on, will come into operation on the 1st of July 2021. Next slide. The prior authorization. This, as I was preparing, I realized this might be very closely related to the work conducted by the members of the Institute of Commercial Forensic. And this is, if you look at section 57.1 of POPIA, it provides that a responsible party must obtain prior authorization from the regulator. That authorization, you can only obtain it once, except where the processing depart from that which has been authorized. But you need to obtain that prior authorization prior to any processing if the responsible party plans to. The first one, if you plan to process any unique identifier are like your ID number, your registration number of a company, any policy number, those will be an example of unique number. So if you plan to process any unique identifiers of data subject for a purpose other than the one for which the identifier was specifically intended at collection, and with the aim of linking that with the information processed by other parties. An example would be, let's say you're conducting a forensic investigation. The personal information that you process, normally you'll get it from the company that you are representing. If the regulator appoints a forensic company to conduct forensic investigation, they will be provided with the personal information of that responsible party, including the personal information of the employees. And if you then want to link that information with the information, for example, under the criminal record of the SAPS or with the company CIPC, the Company Intellectual Commission, information contained by that other company, that might fall under this requirement. And therefore you might have, unless you've got a code of conduct, you might have to obtain the prior authorization from the regulator. As I indicated, you only obtain this once, and you only come back to the regulator if you want to deviate from the approval that you have obtained. So that might fall under the prior authorization, and our advice is that please look closely to this requirement of unique identifier that you are going to link it with the other information which are processed by other responsible parties. So the example that I give, it may not be directly related because I don't know exactly how the information is being processed by the forensic, but it's just an example that I thought of, that once you receive your information as a forensic company, sometimes you go and link the information with the information under the CIPC. You also go and check the criminal record and or conduct anything. So the CIPC can perform its own information. Once you link what you have, information that you have with that CIPC, that might fall under section 57.1, and therefore you might have to obtain prior authorization. But please go and check properly your processing, whether my example might be closely related, because I do not have the inside information on how that information will be processed. I just thought this might be closely related to that. Next slide, please. So also, if you plan to process information on criminal behavior or unlawful or objectionable conduct on behalf of third parties, this is also very closely related with the work that you might be doing as a forensic company. So if anyone's going to process the information on criminal behavior or unlawful objectionable conduct on behalf of third parties, that obviously you have to obtain the prior authorization from the regulator. So if you're going to do that, then get prior authorization. If it's the nature of your work as a responsible party, so you get prior authorization once and you'll be doing that forever, unless you want to deviate from the authorization that you have obtained. Also, if you plan to process information for purpose of credit reporting, this is related mainly to the credit bureaus, your TransUnion, your Experian. They cannot perform their work unless they've got a code of conduct without the prior authorization of the regulator, which means this is with regard to those industries, the credit reporting industry, they have to either submit their code of conduct. If they don't, they need to then make an application to the regulator and get the prior authorization. If we do not grant the prior authorization, it means they cannot perform their duties anymore, because that falls under credit reporting. Also, if a responsible party plans to transfer special personal information or the personal information of children to a third party in a foreign country, that does not provide an adequate level of protection for the processing of personal information. If you want to do so, then you need to get a prior authorization. In other words, we have a responsibility to ensure that the information officers, personal information of South Africans should not be transferred to a country which does not respect the personal information. So if you're going to transfer personal information to a country that does not provide that adequate, you have to get prior authorization, motivate why you need to transfer, what is the purpose, and obviously you need to indicate what will be the measures that you have for the regulator to approve that. So as I indicated earlier on, unless a code of conduct has been issued by the regulator and has come into force in a specific sector or industry in which the responsible party operates, the responsible party who is currently processing or intend to process the personal information of data subject, which is subject to prior authorization, must submit the application prior to processing or any further processing. Let me give an example. Currently, you've got the credit bureau industry that is currently processing their personal information, and they don't have a prior authorization from the regulator. Come the 1st of July, they are currently doing that. Come the 1st of July, if there's no code of conduct issued, and if they have not obtained the prior authorization, they cannot continue processing that personal information because that will not be in line with POPIA. So it means even if currently you are doing so, if you want to continue doing that, come the 1st of July, you've got to be in compliance with Section 57 of POPIA, or 57 and 58 of POPIA. So the application for prior authorization and the guidance note, as I indicated, may be downloaded from the regulator's website. So there is a guidance note on prior authorization that we have issued. It is available on our website. Responsible parties can go through the guidance note. We have given an example in the guidance note to ensure to make sure that there's a proper understanding of how the regulator will grant this application and what the requirement. So if you go to the website, that information will be able to assist. That guidance note will provide proper guidance on how this application for prior authorization should be done. There is an application which is available, application form that can be downloaded, and those applications can now be submitted to the regulator as well. If your processing is subject to prior authorization, you need to ensure that those applications are submitted before the 1st of July, because 1st of July, any processing that's subject to prior authorization and you do not have that prior authorization, that would be unlawful and the regulator may issue administrative fine. The next slide. So what are the prescribed time frame for finalizing the application for prior authorization? We intended to deal with this so that because we feel that this is much closely related to the industry in which the commercial forensic belongs. So the regulator may approve or reject an application for prior authorization within 4 weeks of receipt of prior authorization application, unless the regulator decides to conduct a detailed investigation. So in your application, make sure that you provide sufficient information to enable the regulator to be able to process and grant you application within 4 weeks. If there's no sufficient information, that may require the regulator to conduct a detailed investigation. And that obviously means it will delay the approval process. So in the event that the regulator decides to conduct a more detailed investigation, the regulator will inform the responsible party in writing of the reasonable period within which it plans to finalize a detailed investigation, which period should not exceed 13 weeks. So will not exceed 13 weeks for us to grant you, to process that application for prior authorization. Next slide. So let's say we decide to conduct a detailed investigation. So on conclusion of the detailed investigation, the regulator will issue what we call a statement, or you can also call it a report about the lawfulness of the information processing. So if a statement or a report conclude that the information processing is not lawful, such report or statement shall be deemed to be an enforcement notice served in terms of Section 95 of POPIA. So if we conduct a detailed investigation, we do not believe that, for example, let's say you want to transfer the personal information or special information outside the Republic, and we do not believe that such processing, transfer of that personal information is lawful, we'll issue a report wherein we then require you not to process that personal information. That report or statement will constitute an enforcement notice, which means if you don't comply with it and continue processing, maybe transfer that personal or special information, then it means that you are in breach. The regulator may issue an administrative fine of a maximum of 10 million that they can issue. Next slide. However, if the regulator fails to finalize the application within the prescribed period of 13 weeks, so let's say, for example, you submit an application, the regulator's investigation took longer than expected, so there's 13 weeks passed. The responsible party may presume a decision in its favor and continue with its processing. So if you make an application and the regulator doesn't come back to you within 13 weeks, then you can proceed with the processing that you want to proceed, because that's a presumption that the decision is in your favor. However, this presumption is rebuttable, meaning that should the regulator find that the information processing is unlawful, the responsible party, sorry, there's just a message appearing here I cannot see. The responsible party will have to comply with its directive as contained in the statement. So if at the end, even after you continue processing, the regulator finalizes detailed investigation, found that the processing is unlawful, then automatically that report, once it's issued, it constitutes an enforcement notice, and you need to then stop, cease the processing of that personal information. Next slide. My presentation will end here. The chairperson will deal with the challenges as well as the conclusion. I'll hand over to the chairperson. Thank you.
Thank you very much, Mr. Namasisi. The last slides really is just what you requested us to deal with, the challenges that are also in the slide presentation. Functionally, one of the challenges is that functionally the regulator operates independently, but administratively it still uses the policies and systems of the Department of Justice and Constitutional Development. And that affects the speed with which we want to do things, because as you know, the department is very big and we are just a tiny unit in the department. So the sooner we are able to operate completely independent functionally and administratively, that will assist us. We have lack of resources, adequate resources to establish the administrative capacity of the regulator. We have been given, I mean, we started with a budget of 45 million rands, but for this financial year, our budget was increased by about 90%, and we're one of the few institutions whose budget was increased by National Treasury. So we have a budget of almost close to 100 million, which is still not sufficient, taking into consideration that we are a startup and we have to establish this organization from scratch. So we don't have, our resources are not adequate to execute our broad mandate. But what we are also discovering is that there is lack of a critical mass of experts in POPIA in the country. And we are appealing to everyone to ensure that they acquire expertise in this country for us to be able to deal with this work efficiently. I mean, from of course, there are lawyers who are experts, but we not enough. We need IT experts, forensic investigators, and so on in this area of our work. And then lastly, in conclusion, in the last slide, we have just indicated the guidance notes that we will be developing and issuing before the 30th of June, which is the guidance note on exemptions from conditions for lawful processing of personal information. If you look at the Act, this is provided for in section, I think it's section 36 to 38 of POPIA, and then guidance note on notification of security compromises or data breaches. We want to standardize that so that the notification that we received from responsible parties that have been breached in terms of the format that will be in the guidance note. We'll also be issuing a guidance note on processing of personal information across our borders. We'll be issuing a guidance note on direct marketing in terms of section 69, which is provided for in section 69. It's a big issue there, particularly on the meaning of unsolicited electronic communication. What constitutes electronic communication. We need to issue a guidance note in that regard. And finally, we'll issue a guidance note on application to process special personal information and personal information of children. So we still have a long way to go. We have started, within the best of our ability, we've done what is humanly possible. Thank you very much. We will take questions.
Thank you, Advocate Hlekula. I think you've covered quite an extensive, both yourself and Mr. Nemasisi have covered an extensive explanation in terms of the legislation and the requirements for compliance. And I think what is coming out clearly is that most of the service providers that are in the forensic fraternity need to develop their compliance frameworks and ensure that they do their own impact assessments on what is the impact before 1 July, so that come 1 July, everybody is compliant with the legislation. And the issue of prior authorization and the guidance notes in terms of the code of conduct is, I think, of imperative importance for forensic investigators in terms of how they actually apply for the consent in terms of section 57.1. And Vuyo, thank you, Vuyo. And I think the requirements insofar as the code of conduct and developing the code of conduct will become quite important for the forensic fraternity. But I see there are a few questions. Perhaps if we can take, I think the first one is from Nico. And the first one is, do you have to obtain authorization for each different type of data you process, or is it a once-off authorization? So I'm not sure, Advocate Hlekula or Mr. Nemasisi, who would take this question before we move to the next one.
I think, Ms. Nemasisi, you can take the question.
Thank you, Chair. As I indicated, it's your responsibility. Your responsibility is your duties as a company is to process that particular personal information. You obtain the authorization once, unless you deviate from the authorization that has been granted by the regulator. So, in other words, let's say you said you process personal information for conducting a forensic investigation, this kind of forensic investigation, and then your company grows, and then you then conduct different forensic investigation, which processing may not be the same with the authorization that you have obtained. That you have to obtain another authorization. But if for the work that you do is constantly the same work that you have already obtained the authorization, there's no need for you to go and apply again. That authorization will continue as it is unless the regulator revoke it. But it will continue as it is. You do not have to apply every time you want to process. So if you're continuing your work, it's always being the same, and it's not deviating from what has been authorized, you do not have to apply again. That authorization continue, and it does not have expiry dates per se, unless the regulator puts certain conditions. Thanks.
Thank you, Mr. Nemasisi. I hope, Nico, you are covered with that question. There's another question that has popped up, and I'll go through it. It says, we attach witness statements to our reports for disciplinary investigations. The witness statements contains personal information. We issue the report to the client. From there, the report is distributed to board members and the shop steward that represent the accused, and sometimes to external lawyers, organizations such as Scopa. How should we deal with this in the future? Mr. Nemasisi, would you take this one?
Sorry about that. In other words, if there's any processing that falls under the prior authorization, once it's authorized, once that process has been authorized, you should not be worried about the issue of compliance. So when you make an application for prior authorization, you need to specify what is the nature of processing that you require authorization, and the regulator will make a determination. In making a determination, the regulator will look at several issues, and that we detailed in the guidance note that's available. So if you satisfy those requirements, the regulator will grant you an authorization to process those personal information and the manner in which you're processing the personal information. So it's important that when you make an application, you detail your application so that it can enable the regulator to be able to assess And obviously, if certain processes may not be in line, the regulator will indicate which processes should not be done, which one should be done. But because you are required to comply with POPIA, but with an exception of what the regulator can authorize. So that will depend on the nature of processing. I may not give you a direct question now because I'm not sure what contained in that statement, and is it part, does that statement will fall under the definition of prior authorization? Remember, there's also other requirement for an exemption that a responsible party may make. The chairperson has indicated that we are actually developing an exemption. We actually at the stage where we're about to finalize the exemption from certain conditions. So you might find that if your processing is not subject to prior authorization, you may as well use an exemption as one of the tools to be exempt from certain processing. As the forensic as well, depending on who you are conducting forensic for, there you will see in the guidance note when we issue, we're going to issue shortly. You'll see in the guidance note, we're going to cover that. There's two types of exemption. There's one in which you have to obtain it from the regulator. There's another one in which you call it an automatic exemption. But the automatic exemption is the one in which, by the nature of the processing, if you're processing personal information for a public body, we'll give detail in the guidance note. You might find that such processing is automatically exempted, but it's not exempted from POPIA. It's exempted from certain conditions for lawful processing of personal information. That's not a general exemption. It's just only few processing. For example, notifying a data subject that you are collecting the personal information. Those are the some exemptions that are automatical, but it depends on the nature of processing that you are doing. If you are doing it for the public body, that might be exempted, but we'll provide a detailed guidance note on that aspect of exemption. For now, the guidance note on prior authorization is there. I'll request that the responsible parties to go to our website and check those guidance notes and see if they satisfy themselves before they can actually apply for the prior authorization if their processing falls under the definition of prior authorization. Thank you.
Thank you, Mr. Nemasisi. I think the question relating to, you answered it to some extent from Andre, relating to Section 36, Section 37, and Section 38 of the Act, in terms of exemptions from conditions for the processing of information by statutory bodies like SAPS and SARS in criminal investigations during the conduct of criminal investigations are obtained. Are they exempt in terms of these provisions, or are they generally exempt in terms of the Act? Mr. Nemasisi.
Look, the exemption in terms of Section 36, it details actually what are the things that you can be exempted. You can be exempted from the conditions for lawful processing of personal information, but the regulator will look in your application. They'll look whether the issue of public interest in the processing outweigh to a substantial degree any interference with the privacy of data subjects. So if you're conducting a criminal investigation, obviously, that is for the people that might fall under the definition of public interest. And that will be one of the conditions that the regulator will look at. If there's a public interest outweighs to a substantial degree the actual interference, then for the regulator will provide and grant you an exemption. The other requirement that the regulator will look at for exemption, it will be in terms of Section 37, it will be if the processing involves a clear benefit to a data subject. Let me give you an example. If you are actually processing personal information, you want to transfer this information, put it somewhere in the storage, and you want to be exempt maybe from one condition that deals with the issue of, I can't remember exactly what it might be, but if that transfer is for purpose of ensuring that the personal information is secured somewhere, that you might find that that may be a benefit to a data subject. So anything that will be a clear benefit to a data subject, that may, if you certify that requirement, the regulator may grant you an exemption from a condition. So this is not an exemption from all the conditions. It's only you need to specify which condition you want to be exempt from, and the regulator will check public interest, will then check also the clear benefit. But that will be detailed in our guidance note for exemption that will be issued shortly, and will indicate how we're going to process those applications for exemption. So like I indicated, the other exemption is the one in which it's, which we call it an automatic exemption, which means you don't have to make an application to the regulator. It's by operation of the law, but you've got to be very careful with regard to the automatic exemption, because misinterpretation of Section 38 may result in the interference with the processing of personal information, which the regulator may impose penalty. So that Section 38, it's not a simple one. It has to be properly interpreted whether your processing fall under that section, because any misinterpretation automatically fall into the interference with the processing of personal information, and the regulator will then enforce compliance. Thank you.
And can I just add to what, because Mr. Namasisi has covered exemptions, part of that question deals with exclusions as well. To say that is the SAPS excluded from the operation of the Act. And to deal with that, we have to look at Section 6 of POPIA, in particular Section 6(1)(c), subsection 2. And we are still going to look at those exemptions. We've started with exemptions. We'll then have to interpret and maybe issue a guidance note to say who is excluded. Because if you look at that 6, it says a body, the purpose of which is the prevention, detection, including assistance in the identification of the proceeds of unlawful activities and the combating of money laundering activities, investigations, or proof of offenses, the prosecution of offenders, or the execution of sentences or security measures, to the extent that adequate safeguards have been established in the legislation. So whether SAPS is wholly excluded from the operation of POPIA in terms of Section 6 is something that we still have to debate and agree on in the information regulator. Thanks. I thought I should cover that because the question also related to that aspect.
Thank you, Advocate Lekula. I think maybe just lastly, in the interest of time, I see there's a number of questions and we can't take all of them, but the common thread that is coming out and the questions that revolve around the code of conduct. And I see there are some comments about the code of conduct, for example, in terms of CIRA or other bodies that might have a code of conduct. Perhaps if Advocate Namasisi can just clear this issue about the development of the code of conduct and whether as the ICFP, do we need to develop and have a code of conduct approved by the information regulator that would cover the members registered with the ICFP for the entire forensic industry, or how do you see the code of conduct being developed, and what are the proposals or the guidance in terms of the code of conduct so that members could be clearly understand whether a code of conduct is industry-wide or is company-specific? Thank you.
So much. I think Chair will also add on this one. What we, as the regulator, we have issued a guidelines to develop a code of conduct. So those guidelines are available on our website. We'll request that maybe responsible parties or member of the commercial forensic then go and look at those guidelines. But in summary, the guidelines specify who can apply for a code of conduct. I gave an example during the presentation that, for example, what's the name of this entity? The Institute of Commercial Forensic has got practitioners. So it means it's a body representative of the industry. So it is the Institute of Commercial Forensic Practitioner. If it decides to have a code, because it's not a requirement that you must have it, but if it decides to have a code of conduct, it can develop a code of conduct that regulates the industry. But there's a qualifying requirement for that code of conduct for it to be issued. The critical one is the sufficient representative. So if the institution or the Institute of Commercial Forensic Practitioners has sufficient representative, meaning in other words, in the whole country, if your membership constitutes more than 50+1% of the whole industry, then your code of conduct will be issued by the regulator. And that's the code of conduct that will then regulate your members on how they can process personal information. The advantage of having this code of conduct issued by the regulator is that you will not have, if you're processing subject to prior authorization, your members, meaning the responsible companies that are forensic companies, they do not have to apply for a prior authorization because there's a code of conduct that has been issued. So it's not a private company that will have to apply for a code of conduct. It's a body representing those companies that has to apply for a code, and that code will then bind its members. And so one of the requirements you see when you go into the guidelines that we have issued, which are available on the website, the only requirement that you need to have in your application is that do you have sufficient representative? And this guide, your code will be published for public comment. So if there's another body that may be competing with your body, they will indicate which one has got sufficient representative. And if we believe that you do not have sufficient representative, the code of conduct may not be issued. So it's very important that you have to do an assessment whether you've got sufficient representative. If you do, then you may have to consider whether to develop your own code of conduct that will regulate your industry. And if you meet all the requirements, that code of conduct will be issued. And once it's issued, and if your processing is subject to prior authorization, you do not have, your members do not have to apply for prior authorization. And also, as I indicated, one of the critical things is what you may have is that in your code of conduct, you may have to indicate whether you want to deal with the complaints that may arise from the code of conduct. So if you decide to have that, you deal with that in your code of conduct, you'll have to appoint an adjudicator. So we have issued those guidelines and the certain related documents that are available on our website to guide relevant bodies, which might be, for example, your institution, who intend to issue who intend to have those code of conduct in their industry. Thanks.
Let me assist you, Program Director, because I can see that the time is gone. I think some of the questions, if you can do this, if you can send them to us, to the regulator, we'll then be able to respond to those questions in writing, because we don't have enough time to cover all the questions, but simply to just say, to deal with a question that says that if you already have that somebody, I don't know, they say investigated, registered in terms of PRISA, already have a code of conduct. We have to be clear here that the code of conduct that we are talking about is a code of conduct that deals with processing of personal information. So it's a specific code of conduct, and it has to be issued by the information regulator if you decide to use that code of conduct, if you decide to adopt a code of conduct. So existing codes of conduct that do not deal with the processing of personal information are not relevant for our purposes. I think we have to make it very clear. But the rest of the questions, please send them to us, to Mr. Nemasisi or to Ms. Zodwa Rikotso, and then we'll try to respond to them in writing. Thank you.
Thank you, Advocate Lekula. I think the ICFP, through its board, will facilitate that communication with your officers and ensure that these questions are provided so that you can provide an adequate response, so then we can engage with our members and provide the feedback that is required. Thank you. I think with that, I think we would await the guidance notes. I think there's a lot of guidance notes that are still coming out. I think for myself, I'll be looking forward to the guidance note on direct marketing, like many other people who get harassed and called and emailed all the time during the day by many telemarketing service providers. So I think that guidance note will be on a lighter note. That will be quite interesting to have a look at, to see how that industry becomes regulated. But once again, thank you, Advocate Lekula, as well as Mr. Nemasisi, for the detailed and very insightful presentations, as well as the response to the questions provided. Thank you so much. We will now proceed to the next presentation by Jeanette Reeder, who will also give some practical insight into some of the issues that she's going to cover. She's also going to cover the retention of records, some of issues also as touched by Mr. Nemasisi on the exemptions, prior authorization, consent, and the role of information officers. So with that, I hand over to Jeanette to continue with her presentation. Thank you, and then we'll take questions at the end of our session.
Thank you very much. I appreciate the opportunity to make this presentation. A lot of the issues that was handled by the speakers before me of the regulator has also been dealt in the slides that I'm going to present to you, and I'm not going to duplicate those presentations. So I'm going to try and concentrate a little bit on the practical implications for the investigator in terms hereof. And if Advocate Lakula and Mr. Nemasisi is remaining on the presentation, I think that it will be great if we can maybe have some insight also as to whether the interpretation of the Act is correct or alternatively in line with the way in which the regulator also interprets the Act. So I'm going to share my screen with regard to the presentation. I hope that everybody can see the presentation.
We can, thank you, Junie.
So there is, when we come to the protection of the right to privacy, which is a constitutional right, as well as the protection of personal information, we should distinguish slightly between your right to have your privacy protected, which is the constitutional right, and the execution thereof through POPIA, which deals with the protection of personal information. And it was important, as Advocate Lakula said in the beginning, that we should also consider the definitions of the Act, which I think in this case is extremely important, that when we interpret the Act is that we make sure that we do understand what the definitions of the Act is. Because, for instance, that POPIA kicks in the moment that you are processing personal information. And in terms of POPIA, that happens when you are retaining or capturing information in a record, which might be in a filing system, which might be either electronic or a hard copy filing system. So the moment you obtain information from the day that you take a hard copy document and you put it through a punch and you put it in a file and you put the file in a cupboard, or alternatively you scan it into a computer system or whatever you do with that. The moment you do that and you receive that information and you start processing that information by taking that document or taking that information into some kind of a filing system, for instance, then POPIA kicks in. So you do not or you have to then, as Advocate Lakula also said, make sure that you understand exactly what processing means, because people don't always understand what processing means. Processing doesn't necessarily mean hitting a button on a computer. Processing is also taking any type of document, and especially in the forensic environment, we work a lot with documents. We compile bundles of documents that is annexes or attachments to a report. That report with the information in it, as well as all the documents that we attach to that in order to show the outcome of our investigation. All of that forms part of the protection of personal information. And on the one hand, the investigator who collects this information that needs to respect the privacy of the data subject, the company dealing or the investigation company or the employer of the specific investigator is the responsible party who is, in terms of the Act, processing this information. So you can, as an investigator who sits behind the table and obtain information and capture that in some kind of process or in a report, not divorce yourself from the accountability that attached to the employer that you're working for. For instance, if you're working for a company or if you provide a service as a third party to that company. And when it comes to the protection of the personal information, you need to make extremely or be extremely mindful of the fact that your investigation results on the actions that you take as an investigator. And if you as a forensic practitioner make some kind of mistake, whether it's an ethical mistake or whether you are violating the privacy right or you are violating POPIA's 8 conditions in terms of that, then it can taint the whole investigation. And you need to understand how POPIA works when it comes to the protection of personal information, the protection of your right to privacy, as well as the processing operations that you are going to execute under POPIA when you do your investigation. And you cannot divorce your duty as an individual from the accountability which relies on the responsible party. And you will again have to look at the at the definition of a responsible party. Who is the party who decides about the processing of the information? So if you look at the correct wording of the definitions, you will see that if you just get the definition. A responsible party means a public or a private body or any other person which alone or in conjunction with others determines the purpose of and the means for processing personal information. And if you look at condition 1, you need to understand that there is a difference between responsibility and accountability. The Act holds the responsible party accountable for the processing operations of that responsible party as defined by POPIA. And that accountability, as has been explained to us in detail, relates not only to your criminal liability of the responsible party, and obviously you can't put a company in jail. So who are you going to put in jail? You are going to put the information officer in jail, or you're going to find the company who is the responsible party, or the regulator is going to do that. So that accountability needs to be something which is very clearly understood by the investigator working for you, as well as the company who conducts this investigation on behalf of a client. Now, I think that in preparing this presentation, I could have taken you through the whole Act, and we do these presentations as awareness training, as well as comprehensive training for information officers as well. But that is not something that can be adequately covered in 45 minutes or an hour. POPI deserves more time and attention than that. So what I've done here is I'm going to ask you a few critical questions, and the regulator, Advocate Lukula and Mr. Nemasisi, has very adequately dealt with these issues that directly affects forensic investigators in your environment and in your industry. What I'm going to do with you is look at the same topics, but more ask critical questions of you as to how you deal with this. And also then, in the end of the presentation, quickly just look at what do we interpret an impact assessment, or we call it a POPIA, Personal Information Impact Assessment, and the compliance framework, which Mr. Nemasisi has told you, if you haven't started doing yet, you need to start now. You are going to run out of time if you don't start getting your impact assessment, your compliance framework, and your implementation thereof. You are going to fall foul of the time, and maybe end up in a situation where you think that you are compliant because you have done a few things, but you are actually not compliant because you're falling foul of some of the other conditions. I think that you should understand that compliance to POPIA doesn't mean to 1, 2, or a few of the conditions. Compliance means all 8 of the conditions. What we also then need to understand is when we look at POPIA, very importantly, and that is the framework within which you are going to operate, is that, and Advocate Lukula made this submission as well, is that POPIA doesn't tell you that you may not process personal information, and therefore stifling the client of yours who is now rampantly plagued by criminal behavior of employees or third parties, or alternatively by disciplinary misconduct. And you who have to investigate this, is now your hands are tied, in the sense that the employer can't supply you with this information and you cannot do your investigation, because your investigation is reliant on information. It is reliant probably 99.999% of the time on personal information of employees or of third parties, which is called by the Act as a data subject. So what you need to understand by now is what is required of you as an investigator to protect personal information, and also how are you, or where are you as a responsible party? Because as a responsible party, you not only need to protect the information as you sit behind the desk as the client, you also need to be POPI compliant. And we have got today, if I calculated it correctly, about 78 days to compliance. So what have you done to make your company or your business, whether you are a single practitioner, whether you operate in a PTY or in a partnership, doesn't matter. You're either a person or you who has to comply, or alternatively a corporate or a legal body that has to comply in terms of POPIA. So you need to ask yourself, where are you with regard to compliance? Very importantly, if you are not compliant, you won't be able to execute your mandate by your client. Because if you are not compliant with POPIA, the moment you walk into an organization and you start conducting an investigation and you are starting to process information, either as a responsible party or as an operator, and we will look at what an operator is just now and how this applies to operators. If you are in breach of POPIA and if you are in breach of the privacy obligations under the Constitution and POPIA, you will not be able to execute your mandate. So you need to understand that you need to be POPIA compliant in order to do your work in this instance. It is extremely important to understand the need of compliance when it comes to your business and the service that you provide to a third party. I'm just trying to move to the next slide. It seems like the system has frozen. Apologies for that. So I'm going to quickly look. Can you see the new slide, duties and appointments of information officers? I'm sure you. If you look at the duties of the information officer, and that was now already discussed with us, especially in light of the fact that on the first, the guidance note came out, it is extremely important that you consider this guidance note. It is a well-drafted document, in my view, that gives us a lot of insight into what are the duties of the information officer. And by now, you need to have appointed your information officer. Internally, you need to have made sure that these people know what they are doing, because without this, your compliance processes, your PI, your impact assessment and your compliance framework. The question is, who is going to drive this in your organization? Because one of the main things in which Advocate Tlhakula also said is that we lack expertise. We are privacy immature, if we can call it that, in most of our organizations. And if there isn't somebody or a person or a committee in this instance, can also be, that is designated and delegated to start this process, you are going to be 1 year down the line not sure whether you are compliant or not. And who is better than having the head of the private body, which is a statutory appointment? So you are, by virtue of your position as the head of the private body, public bodies as well, you are, as the head of this body, appointed by law. It is not something of which you can say, sorry, I'm delegating this to an outside person, which it appears is not the correct route. If you look at the guidance note of the regulator, I'm delegating it to a deputy information officer, and now the accountability moves. The accountability does not shift away from the statutory appointment, which is the head of the private body, your CEO or your MD, which whomever is the head of the private body. You cannot say that I have delegated and therefore the accountability does not rest on my shoulders anymore. By law, you are accountable, and you need to understand that by virtue of this accountability, you need to, before you start with your investigation, also make sure that you as a business are also compliant. Very, very quickly, this has already been dealt with by Mr. Nemasisi as well, is that we are encouraged to ensure compliance with the 8 conditions. you need to also ask yourself, how do we comply with the 8 conditions? And your impact assessment needs to consider what are the 8 conditions and how are we going to, in terms of our impact assessment and our compliance framework, comply with each and every one of the requirements that set out in condition 1 to condition 8. You need to deal with requests. Very important. People need to know how to make requests. If you pick up the phone today and you phone a business and you say, I want to speak to your information officer, I want to make a request, you end up with the receptionist or with a secretary who doesn't have a clue what they are doing and what they need to do and what to happen. There need to be a policy or a procedure set up as to what is the processes that we are going to follow to make sure that we deal with a request appropriately. Where's the request going to be sent to? Will we accept telephone calls? Does it have to be in writing? Does it have to be in an email? Who is the recipient of that? All of that needs to be in your manual, and it needs to be on your policy statement, which we advise that you publish on your website with regard to how do you process personal information? Why do you process this? What are the purpose of processing? Where do you obtain the information from? What's your cookie policy with regard to information? How do you execute that? What do you do with this information? People need, in terms of the conditions, not only to give consent, but they also need to be aware of processing. It is your right, if you go and look at section 5 and section 18, which deals with the rights of a data subject. As a data subject, it is your right to know that your information is being processed and what information is being processed. And that needs to take place prior to the processing. So make sure that all of these steps, policies, and procedures are in place. Now, if you look also at your duty to work with the regulator on investigations, for instance, such as prior authorization request in terms of section 56, 57 and 59, I am concerned with regard to the fact that the Act says that processing of criminal, unlawful or objectionable behavior on behalf of third parties needs to obtain prior authorization. Prior authorization, in my view, is critical for the forensic investigator unless you have a code of conduct that deals with this specific issue in your industry, in the way that you execute your investigations. Mr. Nemasisi said very clearly that if you get your prior authorization and the scope thereof and the approval that you get from the regulator or the prior authorization that you get from the regulator, if you operate within those parameters, you don't have to get new authorization. But we all know as forensic investigators, we get different instructions from different clients in different areas. You might in one instant investigate a violation or a breach or unlawful conduct in the medical environment where you deal with medical information, which is special personal information. Then you might be busy dealing with a disciplinary investigation where an employee committed some misconduct in the workplace, which is completely different and a completely different type of investigation than the previous investigation. And my concern at this stage is that the moment the parameters of what you are investigating and the processes that you apply differ from the prior authorization that you have received, then you will have to go back and you will obtain new or different or another set of authorization with conditions from the regulator because you're not operating within the parameters of the previous authorization due to the fact that what you are doing in the investigation that you are conducting is in essence virtually, critically different and from the previous investigation that you did. And the question is now as a organization or as a company, we don't get prior authorization as ABC forensic investigators to go and do investigations. We get prior investigation for a specific investigation that we are doing with relation to criminal, unlawful or objectionable behavior on behalf of third parties. And the question, for instance, also is, well, we all know what criminal and unlawful is, but objectionable behavior, how has that been defined by the regulator. Objectionable behavior on behalf of a third parties, would that, for instance, include disciplinary misconduct, which is not necessarily a criminal conduct, but it is objectionable. So how far will the definition of objectionable be applied by the regulator? Then the next one is also your credit reporting and transborder, especially when you deal with the transfer of personal information of children to a country that doesn't have similar protection. You need to also then get pre-authorization from the regulator. So this might stifle you in the sense when we talk about logistics and when we talk about timelines, because every time that you need to go to the regulator to get prior authorization, you may not process information, and we're talking about a scope of 4 weeks to 13 weeks. And we know in certain instances that clients bring us in and we need to start yesterday. We don't have 4 weeks, we don't have 13 weeks, and the client is bitterly upset about delays because they want this to be investigated. And also you want to prevent the situation where a person that's being investigated does have the opportunity to go and put measures in place in order to refute the investigation. So there are many practical implications for the investigator when it comes to prior authorization. That makes it even more so important to regulate through a code of conduct with the approval of the regulator as to how are we going to deal with this issue. Just what is important here is from the guidelines that has now been published, it seems like the information officer and the deputy information officer should preferably not be a consultant that does not know and understand your business. Although the Act doesn't say clearly that it cannot be an external consultant, you must remember that the information officer is criminally liable and holds accountability. And the intention and the interpretation of the Act in the way that I see it is that the Act will favor management, and as has now been set out in the guideline, that it will favor management or a higher person in management due to the accountability obligation there. You cannot also abdicate this accountability or delegate that to a deputy information officer. So your accountability will remain. And one of, I think, of the good suggestions by the regulator is that your deputy information officer, who is delegated with the functions, that should become part of the job description of that person, so that that employee can be disciplined for not complying with their duties as a deputy information officer. So make sure in your organization that you as the CEO or the head who's running around also doing investigations do have a deputy information officer that can share the delegated functions, although you are not sharing the delegated, or are you not sharing the accountability as is set out in condition 1 to 8. Then the regulator has amplified the duties. The POPIA and the compliance framework, the internal awareness sessions, as well as the manual has been added by regulation 4.1. And then also, please go and read the guidance note that was published on the 1st of March. The practical implications here is important for me, and that relates to consent, which Advocate also dealt with. The investigator will have to work closely with the information officer and the deputy information officer in the future. You know, in general, when we do work for companies, we get our instructions either from HR or from risk or compliance, depending on the size of the business that we are consulting to. And we need to make sure in the future that we are now getting this information under POPIA, and the client needs to comply with POPIA, and you as an investigator needs to comply with the conditions of POPIA. So you need to make sure that in your appointment and in your agreement with your client that you are of accessibility and work closely with the information officer and the deputy information officer.
Jeanette, just sorry to interrupt you, but your audio seems to be going up and down. So I'm not sure if there's something with using a microphone, but sometimes you are quite audible and sometimes you are not. So I see we've got a comment that your audio was not clear.
Okay, I'll try because I'm linked up on fiber, so I should. And it looks like I've got a good connection. So maybe I'm sitting here directing and pointing and moving away from the microphone. So I will try and sit still and move closer to the microphone,
Perfect.
and you can let me know whether that has sorted out the position.
Where you are now is just perfect. Thank you. You may continue.
Okay, perfect. So the next one is that you need to agree when is consent required or practical, because one of the tools that you as an investigator will have working in conjunction with the information officer is to obtain consent to obtain or to process the information, the personal information of third parties or internal employees in the organization. So from a practical point of view, you need to ask yourself, is there consent? It is one of the first questions you will, for instance, ask your information officer, is that in your appointment letters or in your policies and your procedures that you have implemented in your organization, is there consent to process certain information for the purpose of an investigation that may result in criminal liability or may result in disciplinary inquiries? And is that consent informed consent? Because very often we provide consent, but people do not know what they are consenting to. And that is not informed consent as is defined by POPIA. Informed consent relates to the voluntary, specific, and informed expression of will. And you need to also make sure that when there is consent or an information officer tell you there is consent, that that consent actually complies with the requirements of consent under POPIA. And then you also need to ask yourself, to what extent will the investigation be explained to the data subject to enforce informed or to ensure informed consent if you as a investigator get consent? So I know that you work with consent forms. You need to make sure that your consent forms that you currently have when you have discussions, when you have interviews, when you have investigations with people in your investigation, that your consent form is also updated to relate to privacy investigations. And also the question, for instance, that we had where your report is now handed later on to third parties, like for instance a union, like for instance an attorney. Do you have consent to disclose that report to a third party or not? And how are you going to deal with that? So look at your consent forms, make sure that your consent forms comply with the requirements of informed consent, and to what extent do you have that in place in your own consent forms as an investigator?
Jeanette, I'm still getting comments that your audio is very faint. We can barely hear you. You're audible, but it's very faint.
I'm not sure how I'm going to correct. Is that from everybody? Does everybody have the same problem?
It seems so. Okay, it's just come back better now.
I don't understand why it comes and goes. I have linked up via a data cable as well. So I'm not exactly sure how to fix this because I'm not sure where the problem lies.
Okay, you're sounding much better now.
I'm sounding much better now.
Yes.
Okay. So we're dealing now with the question as to whether you are an operator or a responsible party. Now, in my view, when you process information on the instruction of a client, therefore under contract or mandate, without coming under the direct authority of the data subject, therefore the client. Therefore, you are not working at the beck and call of the client. You're not under the direct authority of the client. You're an independent investigator with an independent mandate. Then you will be an operator in terms of the Act. And you will have to look at your duties as an operator, which is specifically mentioned in section 19. Now, some people have got the view that an operator only needs to comply with the security obligations under section 19 of the Act. I don't fully agree with that, purely for the fact that it doesn't make sense to me that you as an operator who sit with all this confidential and personal information of a data subject only by virtue of your operator status has to comply with only one or two conditions of POPIA and not of all of the conditions of POPIA. So you need to make sure that the information is secure and that you've got all the IT processes and all the IT systems in place, but you don't necessarily pick up the other liabilities under condition 1 to 6 and condition 8. And I do not agree that you can skip accountability, if I can call it that, in that sense. So in my view, and the Act to me is not very clear on that, but in my view, the fact that you are an operator gives obligations on you, but it does not necessarily exempt you from the other conditions of POPIA. So maybe we can also at some stage request the regulator to give us some guidelines as to exactly what is the scope of the duties and the obligations of an operator under the operator agreement. What is important here is that the Act requires you to be audited by the client. And this is very important because the moment you act as an operator, the client must ensure that you comply with POPIA. So you will at some stage for a client go through a process where you need to show through an audit process to the client that you are POPIA compliant. Takes us back to the first part of my presentation in terms whereof I said that it's crucially important that you are compliant, because if you are not compliant, you won't be able to act as an operator. You won't pass the audit requirements of your client, and the work will probably go to another investigator due to the fact that you did not pass this requirement as an operator. Vishal, I see it is 3 minutes past 12. The session is scheduled until 12 o'clock. Do you want me to just wrap up in a minute or two, or do you want me to continue?
I think just maybe take another 3 to 5 minutes and just try and wrap up in the next 3 to 5 minutes, because I also see we have numerous questions and we don't want to hold up Advocate Hlakula and Mr. Nemasisi as well, because some of the issues you've raised may necessarily need them to respond or to provide little guidance on the definition of objectionable behavior in section 19. So perhaps next 3 to 5 minutes, if you could wrap up. Thank you.
Okay. So on the retention of PI, very shortly, just what is important here is because the question has been asked specifically on the retention. Remember, you cannot retain personal information for any purpose which goes beyond the purpose for which the personal information has been collected. So if you want to retain it for longer, then you need to go and look at the exemptions under the Act, which allows you to retain the information. And in your environment, my view is that it is predominantly for the retention of your legal duties and for the retention of proof should you go to court at a later stage to have and testify in a criminal procedure or in a civil procedure, and we know that the courts take long. So there are exemptions in terms of which you can retain information. Then you also need to ask yourself, do I then have to restrict the information and make sure that the information is not processed for any other reason apart from the retention of proof? So look at the Act. There are exemptions in terms of the Act, in terms of which you can retain information beyond the purpose, and then also need to make sure that it is restricted if you do so with regard to access. I'm not going to deal with exemptions. Exemptions has been discussed by the Act as well. Codes of conduct has been discussed as well. I'm not going to deal with that. I'm going to, in the last minute or two, just quickly talk about your impact assessment and your compliance framework. And here also, it might be, or we would like to request the regulator to give us some guidelines also as to what is an impact assessment. Because our impact assessments, in my view, in South Africa is different from the impact assessment that you would, for instance, get in GDPR. In GDPR, they have been under privacy regulations and privacy legislation for years now. So your impact assessment is more as to what is new and how do we continuously to comply with privacy legislation. In South Africa, in my view, the impact assessment is more an as is to be. situation. So where are we today? And we are probably 99.9% going to be not compliant. And what do we need to do in order to be compliant, which is our compliance framework that we need to implement, develop, monitor, and update. So in my view, different from GDPR in the sense that we are starting with compliance and we are starting with our assessment. On the left block, you will see that I have mentioned, and it's not all of them, there is a whole list that comes from the Act, but just some main items that need to go into your scoping and your assessment. What we then also do in smart privacy is we work on risk. And this is not only risk for you as a data, as a responsible party, but also risk for the data subject. So we determine risk, we prioritize risk where we find that we are not compliant. We decide on our treatment activities, which also is based on cost, effort, resources, time, and complexity. And then we develop our compliance framework where we again prioritize our risks as well as our treatment actions and our remedial actions. And that is then also implemented, in our view, is that this is a project, this is change management. You cannot on an ad hoc basis try and fix things every time something goes wrong. You need to take your compliance framework, you need to decide what do we implement, how do we implement, when do we implement based on risk, and you execute that in a project implementation sort of way. So that is how we sort of just on a quick bird's eye view see how is the process with regard to the impact assessment as well as the compliance framework. And that is, in a nutshell, some of the pointers that I wanted to leave with you. Thank you very much for allowing us this opportunity, and also have the opportunity to hear the view of Advocate Kula as well as Mr. Nemasisi, which is obviously very, very valuable. Thank you very much.
Thank you, Jeanette. I think you've touched on some very critical aspects in terms of the practical implications for forensic practitioners in light of the job that they perform, and in terms of the information that they would process on a day-to-day basis, and some of the practical challenges and difficulties that one would face as the Act is implemented and the provisions are put in place. But perhaps I'm not sure if Mr. Nemasisi wants to just comment on perhaps three aspects. One is the definition of objectionable behavior, and secondly, on the possible guidelines in terms of Section 19 as the operator, and then thirdly, the impact assessments, if they would be guidelines issued by the regulator in that regard. Perhaps Mr. Nemasisi or Advocate Lekula.
Ms. Nemasisi, you can go ahead, please.
Thanks. I think I'll start with the issue of the guidelines. I think considering our capacity, we have prioritized those guidelines that we have highlighted for now, but there will be other guidelines that will be considered at a later stage. So we prioritize those that we feel that they need to be complied with during the grace period. People need to process certain things before the grace period. So those are the ones that we prioritize, and based on our capacity, we think we can do those, but other ones will be determined as and when. Even during the course of this year, we can still have the guidelines issued. The other question that you have, sorry, I think there was about 3 questions. I think I catch only the one dealing with the guidelines.
The first question or clarity was sought insofar as the definition of what is termed objectionable behavior in terms of the definition.
Oh yes, we covered this in our guidance note for, I just don't have it with me now. In our guidance note for prior authorization, we explain and given a practical example of what will constitute objectionable conduct. One of the examples, if I can remember from the top of my head, that we've given will be, for example, if someone is conducting, you are employing someone, you want to check whether the previous history about their conduct. So that might be interpreted as an objectionable conduct, because that's the conduct which you are looking at for the purpose of determining whether to appoint those people or not. So if, for example, in my previous life, I have committed an offense, and you want or certain behavior that might be unlawful. So those are the examples that we've given, but I would request that maybe go to the guidance note, because I don't have it with me now, where we've given the practical example on what constitutes objectionable conduct. So each guidance, in the guidance note, we give an example of what constitutes unlawful or conduct, what constitutes objectionable conduct. So those are the examples that we've given in the guidance note.
Thank you, Mr. Namasisi. I think the last one was dealing with the impact assessment versus, I think Jeanette raised the issue insofar as GDPR versus the SA context and the requirements for an impact assessment. Would you be setting out certain guidelines insofar as how that impact assessment should be done, and what are the prescripts of that impact assessment?
Like I said, maybe Chairperson will come in on this one. Like I said, for now, we may have the guidance note, but I don't think it would be something that can be issued before the 1st of July, based on the priority and the capacity that we have. But maybe the Chairperson can come in and clarify on this one. Thanks.
Yeah, certainly. Mr. Namasisi is correct. Our capacity is very low, but you also have to bear in mind that after the GDPR came into existence, it took a very long time for our counterparts to be to issue guidance notes. So please be patient with us, because we have prioritized what we think is urgent, but we'll continue to issue guidelines even after the 1st of July. The ones that we are issuing are the ones that will enable, responsible parties to comply by the 1st of July. So at some point, we'll probably come to that and issue a guidance note on impact assessment. But it's not on our priority list at the moment. Thank you.
Thank you, Advocate Hlakula. I think there's just one final question. I'm not sure, Jeanette, if you want to take this question. How does POPIA affect in-house investigation departments? How does this affect both internal and external investigation processes? Jeanette?
So, if it is an internal investigation process that is done by the employer internally, then I think it won't affect you in such a basis that you are an operator. So basically what is happening here when you do an internal investigation, that information is already within the framework of the employer. You are already processing this information. So you will just process it for a further purpose. And that purpose will be a legitimate purpose if it's a legitimate investigation. So I don't think that the Act is going to hamper employers when it comes to internal investigations, because if you process it, it will probably be covered under the further processing condition, whereas you for instance, look at the person's application form. So the purpose of obtaining information for purpose of recruitment is on his application form. So that was the purpose. Now you're doing an investigation and you're looking at what did the person say on his application form to determine whether the person defrauded you on his qualifications, for instance. Under these circumstances, it will be further processing for a legitimate interest. So if you don't have consent for that further processing, then in my view, you will be able to process it as long as that processing falls under further processing, and it is for a legitimate purpose, or alternatively, if you have consent of the employee to do so.
Thank you, Jeanette. I know that we've stepped over time by about 15 minutes, but I think there's a lot that we need to do as forensic practitioners. There's a lot that we need to take guidance from insofar as the regulators concerned. Once the guidance notes have started to come out, and then for us to do some introspection in terms of our internal processes, conduct the internal impact assessments, look at and review our POPIA manuals that are in place in terms of Section 51, do those reviews, I think as the ICFP, we are trying to drive with the regulator the process for the preparation of a code of conduct together with other stakeholders, so that we have a code of conduct for our industry that governs the manner in which we process information, so that we don't have to seek prior authorization all the time. But as Advocate Hlekula indicated, there are challenges, and we need to work together with the regulator to understand how we can overcome these challenges, so that we are compliant, and all of the investigations that are done by both service providers and investigations are done in compliance with the Act. So yeah, we've got 78 days left, which is not a long time, but I'm sure some service providers have taken the step to ensure that they become compliant and understand the provisions of the Act insofar as the 8 conditions for lawful processing of personal information. But once again, I want to thank the panel, Advocate Hlekula. Thank you for your time. I know you are inundated with work and you're busy, but you've taken the time to engage with us. Mr. Nemasisi as well. And Jeanette, for availing yourself to our members to give this insight and to provide this direction insofar as the implementation of POPIA is concerned. Colleagues, I don't see any other questions on the chat group. So we have the questions that have not been answered that we will make available to the regulator. Chris will communicate as the ICFP to the regulator and ensure that the responses are sought and we provide feedback to the members in this regard. Once again, thank you for all the participants. See, we had quite a full group for the active participation, the questions that have come in. I think it was a very informative session, and we may have follow-up sessions as the regulations are enhanced and the guidance notes come out. There may be, as Jeanette indicated, we cannot do this in a 45-minute session. We may need further sessions, and we'll be guided by the members in terms of the requests as well. So Jeanette, thank you very much. To everybody, once again, go well and be safe. Thank you.
Thanks a lot and goodbye to everyone.
Thank you, Vishal. Thank you, everybody.
Thanks.